Welcome back to ACE, your RES exam. Today, we're not just dipping our toes. We're diving headfirst into the legal deep end, specifically Singapore contract law. You've armed us with your detailed notes, and our mission, should you choose to accept it, and you kind of have by listening, is to extract the golden nuggets you absolutely need to smash that real estate salesperson exam.
That's the plan.
Think of this as your express lane to understanding the legal rules of the property road in Singapore.
Exactly. Forget dry textbooks. We're here to make sense of the stuff that truly matters for your future as a property guru.
Right.
We'll be unraveling how contracts are born, what keeps them alive and kicking, or makes them DOA.
DOA.
Yeah.
Dead on arrival.
Dead on arrival, yeah. Those crucial bits in the middle called terms, and the sometimes slippery slope of misrepresentation. Consider this your survival guide to the legal jungle of property transactions.
Exactly. We're zeroing in on the essentials from your notes, starting with the big question, what is a contract anyway?
Yeah.
Then we'll tackle who's legally allowed to play the contract game.
Legal capacity, yep.
The 4 key ingredients for a valid deal offer: acceptance, consideration, and that sneaky intention to be legally bound, and the difference between contracts that are fit for purpose versus those that are duds, void, and voidable.
Big difference there.
Huge. And of course, we'll be putting the spotlight on the star of the show in many property deals: the option to purchase or OTP. Okay, let's unpack this. What in the world is a contract?
Well, as your notes rightly point out, it's way more than just some intimidating document gathering dust. You're actually engaging in contracts all the time, often without even a second thought.
Really?
Yeah. Buying your morning coffee, that's a contract. Getting your hair cut, bingo, another contract in action.
Seriously. So my quest for presentable hair is legally binding. I never thought of it that way.
Absolutely. Though naturally, when we're talking about serious money like that dream condo or, landed property, you'll be helping folks buy and sell. Getting everything down in black and white is the only sensible route.
Makes sense.
It's like having a clear map instead of relying on, vague directions if a disagreement pops up down the line. Understanding this written rule, it can save your clients and yourself from potentially devastating and legally invalid agreements. Imagine relying on a handshake for $1 million property deal. The written rule provides crucial certainty and protection.
That makes total sense. When it comes to property, better safe and definitely written than sorry. Now, your notes mention that generally, if you agree to something verbally, it can be legally enforced. But there's a massive however when it comes to property, right?
Precisely. This is exam gold. According to the Singapore Civil Law Act, specifically Section 6D, any agreement to sell, buy, or otherwise deal with land or property must be in writing to be enforceable by law.
Must be in writing. Got it.
So a charming verbal agreement to sell a bungalow, nice try, but it won't hold up in court. No way.
Got it. For property, if it isn't written, it basically didn't happen in the eyes of the law. And your notes have this fantastic, concise definition. A valid contract is an agreement which binds the parties concerned and is enforceable by law. That's definitely going in the memory bank.
Definitely one to remember.
But you also draw a key distinction between agreements and contracts using a dinner invitation. Explain that a bit more for us.
Yes. It highlights that not every promise we make, even if it feels like an agreement, have legal teeth. If your buddy agrees to meet you for Prada, but then bails to binge watch Netflix...
Happens all the time.
Right. You might be annoyed, maybe very annoyed, but you can't exactly sue them for the missing carbs. That's an agreement lacking the crucial intention to create legal relations.
Go on.
A contract, on the other hand, has that legal oomph. The law will step in, potentially, to make sure the deal is done.
Right. So intention is the secret sauce that turns an agreement into a legally enforceable contract. Now let's talk about who's even allowed to get into these legally binding arrangements. Who has this legal capacity you mentioned?
This is about ensuring that everyone signing on the dotted line has the mental wherewithal to understand what they're getting into. Your notes highlight a few key groups where this capacity is limited. First up, minors.
Minors, okay.
In Singapore, that's generally anyone under 21. Contracts with minors are usually not enforceable against them. Think of it as the law giving them a bit of a safety net while they're still, figuring things out.
So if an 18-year-old signs a lease agreement for a swanky penthouse, they might have a legal get-out-of-jail-free card.
Generally, yes. Now, there are a few exceptions, like contracts for essentials, necessaries, they call them, like food and lodging, but mostly minors are protected.
Okay.
Then we have folks with unsound minds. The law rightly protects individuals who might not be able to make rational contractual decisions due to mental health conditions.
Right.
Similarly, individuals who are seriously intoxicated by drugs or alcohol might also lack the necessary legal capacity. Their judgment is, shall we say, temporarily offline.
These limitations make perfect sense. You need all your faculties firing to make a legally binding commitment. Now let's talk about making it official. The formation of a valid contract. Your notes lay out 4 essential elements: offer, acceptance, consideration, and intention to create legal relations. We really need to nail these down for the exam, right?
Absolutely crucial. These are the 4 legs the contract stands on. If one is wobbly or missing, the whole thing can collapse. Let's start with the offer. What exactly constitutes an offer in the eyes of the law?
From what I gather, it's a clear signal from one person, the offerer, to another, the offeree, saying, I'm willing to do this, and if you agree, I'm locked in. It's like saying, here's my hand, ready to shake on it.
Good analogy.
And you've got some great real estate examples here, like a buyer putting down an option fee or a seller handing over an option to purchase.
Precisely. These actions scream, I'm serious about making this deal happen. And your notes also highlight some non-negotiable rules for a valid offer. It has to be crystal clear and specific. You can't just say, I'll sell you my place for a reasonable price. The key details, like which property and exactly how much, need to be spelled out.
Okay.
The offer also has to be communicated. You can't accept a secret offer someone's just thinking about.
Huh? No mind reading in contracts.
Not usually, no. And an offer can be directed at one person or even a whole crowd, like in some adverts, though that's less common when selling a specific house.
Okay, so a clear, communicated, I'm ready to be bound statement. And offers don't hang around forever, do they? They can expire or be taken off the table. How does that happen?
Several ways. The most obvious is rejection. If the offeree says no thanks, the offer is kaput. Gone.
Simple enough.
The offerer can also revoke or withdraw their offer at any point before it's accepted. However, and this is important if the offeree has paid some consideration.
Which we'll get to.
Which we'll get to, yes. Like that option fee to keep the offer open for a specific time, then the offer can't just change their mind during that period.
Oh, okay.
The fee locks them in. Exactly. An offer can also lapse if a deadline for acceptance passes. If the offer depended on a certain condition being met and it isn't, the offer ends. And sadly, the death of either party can also bring an offer to a close. Bit morbid, but important to know.
Right, got it. Rejection, revocation, unless money changed hands to keep it open, running out of time, unmet conditions, and the ultimate deal breaker, death. Now, this invitation to treat, it sounds like a legal loophole where things that look like offers aren't really offers. What's the story there?
Think of it as the difference between putting something up for sale generally and actually offering to sell it to you right now, personally. An invitation to treat is basically saying, hey, we've got this for sale, come make us an offer.
Okay.
Think of a price tag in a shop. That's an invitation for you to offer to buy it at that price. The shop can then say yes or no. Why? Maybe I've only got one left, maybe it's reserved.
Right, limited stock.
Exactly. Similarly, most advertisements are invitations to treat. They're trying to lure you in to make an offer, leading to potential bargaining or negotiation.
So that luxury penthouse for sale ad isn't legally obligating them to sell it to me at that price right then and there.
Not necessarily, no. It's inviting you to make an offer. Auctions are another prime example. The auctioneer banging the gavel and saying, who'll give me $1 million? That's an invitation to treat. Your bid is the offer.
Ah, my bid is the offer.
Your bid is the offer, and going once, going twice, sold. The fall of the hammer, that's the acceptance. No hammer, no deal.
Got it.
And finally, notices asking for tenders are usually invitations to treat unless they specifically promise to accept the lowest bid or highest, depending. That specific promise might make it an offer. It all hinges on the intention to be immediately bound upon acceptance.
This is crucial for anyone in real estate where you're constantly in negotiation mode. Differentiating offers from invitations is key. Okay, next up. Acceptance. Once an offer is on the table, how do you seal the deal?
Acceptance is the offeree saying a clear and enthusiastic yes to all the terms of the offer.
All of them.
All of them. Unqualified. And they have to communicate that yes back to the offerer. That word unqualified is key. If you try to sneak in a change or add a condition like, I accept, but you have to paint the living room green,
No.
That's not acceptance, it's a counteroffer.
Yeah.
Which, as your notes mention with the classic Hyde v. Wrench case, effectively kills off the original offer. It's a rejection of the original offer and a new offer on the table.
So if a buyer offers $1 million for a place and the seller replies, "We accept, but only if you throw in your vintage scooter collection," that's a counteroffer, not an acceptance of the $1 million offer.
Exactly. The original $1 million offer is gone, and the acceptance has to come from the offeree themselves or someone they've officially authorized to act for them. Your chatty neighbor overhearing you and running to tell the seller they accept probably doesn't count.
Probably not.
Unless you've actually appointed them as your agent, formally. Importantly, the offeror generally needs to receive the acceptance directly. Silence is a big no-no as acceptance. You can't just send an offer and say, if I don't hear a peep from you within a week, you've accepted. Doesn't work like that.
Unless you've specifically agreed to that beforehand, I guess, which sounds like a recipe for misunderstandings.
Precisely. Clear, direct communication is always the safest bet. And your notes rightly highlight the importance of the mode of acceptance. If the offer specifies a particular way to accept, say, signing and physically returning the option to purchase to their lawyer by a certain date,
Very specific.
then that's the method that must be used. This is especially crucial in real estate to generally avoid relying on the old postal rule of acceptance, which usually says acceptance happens when the letter is mailed.
Right, you need certainty.
In property deals, you need that signed OTP in hand or at least received by the designated person. Timing and location are everything.
Absolutely. You don't want any he said, she said when you're talking about property transactions. All right, moving on to consideration. This always sounded like some fancy legal jargon to me. What's the everyday way to think about it?
Think of it as the what's in it for me part of the contract. It's what each party gives or promises to give in exchange for the other party's promise.
Okay.
As your notes cleverly put it, it's the price for which the promise of the other is bought. In the world of real estate, consideration is usually cold, hard cash, the deposit you pay, the final sale price.
Money.
Mostly money. But it doesn't have to be money. It could be goods, services, or even a promise not to do something, like not competing in a certain area.
Okay, so it's the value that each side brings to the table. Your notes mention 4 key rules about consideration. First, it need not be adequate. What does that mean in plain English?
It means the law doesn't really care if you're getting a screaming deal or paying way, way too much as long as both parties freely and willingly agree to it.
So market value isn't the point.
Market value is generally irrelevant to the validity of the consideration itself. If someone is happy to sell their $1 million condo to you for, say, $100, and you both genuinely agree, that's legally fine in terms of consideration. The law won't step in and say, hold on, that's not a fair price.
Freedom of contract, eh?
Exactly. Though keep in mind that extreme inadequacy might raise a red flag for other potential issues, like undue influence or maybe lack of capacity, which we can touch on. But just the value itself doesn't invalidate the consideration.
Right, so a bargain is still a bargain legally speaking. But the second rule says consideration must be sufficient. How is that different from adequate? It sounds like the same thing.
It's a subtle but important distinction. Sufficient means the consideration has to have some actual value in the eyes of the law. It needs to be real and tangible, not just something vague or, like, illusory. That small option fee you pay, even if it's just a token amount like $1, is considered sufficient consideration to make the seller's promise to keep the offer open legally binding. It has a real legal value, even if it's not adequate compared to the property price.
I see.
Think of it this way. Selling a luxury condo for $1 is inadequate in terms of market value, but sufficient in the eyes of the law as long as both parties willingly agreed. However, promising to be nice to the seller or offering love and affection isn't sufficient consideration because it lacks real, tangible, legal value.
Okay, so adequate is about the amount or market comparison, while sufficient is about the kind of value something the law recognizes.
Got it.
Got it. The third rule is that consideration must be current. No past favors counting as present payment.
Right.
This Ben and Steve warehouse example really made it click for me. Can you remind us of that one?
Sure. Imagine Ben lets Steve store his stuff in Ben's warehouse, just as a friendly gesture, no mention of payment. Then, after Steve has already moved everything out, Steve says, "Oh, thanks, Ben. I promise I'll pay you some rent for that." That promise is based on past consideration. Ben letting Steve use the warehouse wasn't done in exchange for Steve's later promise of rent. It was a favor done in the past. Generally, past consideration isn't good enough to support a new promise.
Right.
However, if Ben and Steve had agreed on rent before Steve moved his things in, then Ben allowing him to use the warehouse would be what we call executed consideration, an act done specifically in exchange for the promise of rent. That is perfectly valid consideration, so the timing of the give and take is crucial.
So you can't just promise to pay someone for something they already did out of the goodness of their heart, expecting it to be legally binding. The price has to be linked to the promise at the time, and the final rule is that consideration must move from the promisee. Explain that one for us.
This means that the person who's trying to enforce a promise must be the one who actually provided the consideration for that promise. The Helen buying a sofa for Johnny and Mary example illustrates this well.
Right, the sofa example.
Helen is the one who shelled out the cash for the sofa from Chip Stuff Furniture. If the sofa falls apart, even though Johnny and Mary are the ones using it and suffering, they generally can't sue the furniture shop because they didn't provide the consideration, the money. Helen did. She's the promisee who paid the price, so she's the one who can sue.
Right, so you got to be the one who put something on the line, the consideration, to have the right to enforce the deal against the promiser. Makes sense. Finally, we have intention to create legal relations. This sounds a bit like mind reading. How do the courts figure out if people intended to be legally bound?
Yeah, it does sound a bit like that, but the law takes a practical, objective approach. It looks at the situation and asks, would a reasonable person, knowing all the circumstances, think that the parties intended to create a legally enforceable contract?
An objective test.
Exactly. Your notes helpfully divide agreements into two main types here: social and domestic agreements and business or commercial agreements. The law makes different assumptions or presumptions for each.
And the default assumption is different for those two types.
Right. Exactly. For social and domestic agreements, like a casual promise between family members or friends. Remember the husband promising his wife an allowance in the famous Balfour v. Balfour case?
Vaguely, yes.
Well, in those situations, the law presumes there is no intention to create legal relations. The thinking is that these sorts of promises are usually based on goodwill, trust, affection, not meant to be legally binding contracts you'd sue over.
Yeah.
However, as the Merritt v. Merritt case with the separated spouses shows, this assumption can be overturned or rebutted if the circumstances clearly suggest otherwise. Maybe they put it in writing, maybe the relationship had already broken down.
So a casual pinky promise to a friend is different from signing a formal business partnership agreement.
Precisely. In business or commercial agreements, the opposite is generally true. The law presumes there is an intention to create legal relations.
Makes sense for business.
After all, the whole point of most business deals is to create legally binding obligations. This is almost always the case in real estate transactions. When someone is selling a property and another person is buying it, there's a very clear intention to enter into a legally binding agreement. The law wants to give effect to these commercial dealings.
Okay, so those are the four pillars of a valid contract: offer, acceptance, consideration, and intention. Master those, and you're well on your way to acing the legal bits of the RES exam. Now, your notes then delve into what happens after a contract is formed, looking at valid, void, voidable, and unenforceable contracts. Only valid contracts are the ones you can actually take to court to enforce, right?
Absolutely.
Yeah.
A valid contract has all four essential elements we've just dissected and can be enforced by either party if things go south. But what about the others? Let's start with a void contract. What's the legal status of that?
A void contract, as I understand it, is a complete legal non-starter. It's as if it never existed in the first place. Null and void from the get-go. Nobody can enforce it. Your notes give some pretty clear-cut examples. Deals involving illegal activities, contracts with someone who completely lacks the mental capacity to understand what they're doing, agreements to do something utterly impossible, or contracts that go against fundamental principles of public policy.
Correct. It's flawed from the very beginning, fundamentally. Now, a voidable contract sounds kind of similar, but there is a really crucial difference.
Yes, a voidable contract is valid when it's initially formed, but one of the parties has the option to pull the plug to void it or rescind it. The party who got the short end of the stick, so to speak, gets to choose.
Exactly. So it's valid until it's voided.
Right. Classic examples include contracts entered into with minors. The minor usually has the right to cancel, or contracts where someone was pressured, misled, or unfairly influenced into signing.
Duress, misrepresentation, undue influence.
Or where one party lacks full capacity but not completely, maybe due to intoxication.
Exactly. The contract exists and is binding unless and until the disadvantaged party decides to set it aside, usually within a reasonable time. Your notes also introduce the term vitiating factors here. These are things like misrepresentation, duress, being forced, undue influence, being unfairly persuaded, certain types of mistakes, and illegality that can mess with the agreement and make a contract either void or voidable.
So these are the potential tripwires in the contract landscape. We'll definitely be circling back to misrepresentation. But before that, let's quickly touch on the actual promises within the contract, the terms. You differentiate between conditions and warranties. What's the key difference a future real estate agent needs to know?
Okay, this is important. Conditions are the really fundamental make or break terms of the contract. They go to the very root of the deal. They're so important that if one is breached, the innocent party has the right to not only claim money to cover their losses, damages, but also to rescind the entire contract to treat it as ended.
Wow, okay, so breach of a condition is serious.
Yeah. Very serious. Warranties, on the other hand, are less vital, more secondary promises or obligations. If a warranty is breached, you can still claim damages to compensate for any loss you suffered because of the breach, but you generally cannot just walk away from the whole deal. The contract itself remains in force.
So a broken condition can sink the whole ship, while a broken warranty is more like a leaky faucet. Annoying, maybe costly to fix, but you can still sail on. Got it. Now let's plunge into the murky waters of misrepresentation. This feels like a minefield for real estate agents, right?
Absolutely crucial for anyone in the property business. Misrepresentation is essentially making a false statement of fact to someone that persuades them or induces them to enter into a contract, and they end up suffering a loss because of it. It can be spoken or written, and always happens before the contract is officially formed, during the negotiation phase. As a real estate salesperson, you are the primary point of contact for potential buyers. Ensuring the accuracy of information you provide isn't just about legal compliance. It's about building trust and maintaining your professional reputation. Misleading a client, even unintentionally, can have serious consequences for you and your agency.
So it's all about those pre-contract conversations and descriptions that influence someone's decision. Your notes break down the important elements of misrepresentation. The first is a false statement of fact, and you emphasize past or existing fact, not opinions or future predictions.
Correct.
So me saying this apartment has amazing feng shui, or this area has great appreciation potential, that's likely opinion or puffery.
Generally, yes. Puffery or your personal opinion about a property's charm or future potential usually won't count as a statement of fact. Buyers expect a bit of sales talk.
But me saying this building had a major renovation last year when it didn't, or the roof was replaced 5 years ago when it was 20, that could be misrepresentation.
Exactly. Those are statements about existing or past facts.
Right.
If they're false, that can definitely be misrepresentation.
What about keeping quiet? If I know about a, say, persistent leak in the ceiling, but the buyer doesn't ask specifically about leaks, am I legally obligated to spill the beans?
Generally, the rule in Singapore is that silence by itself does not equal misrepresentation. There's usually no general legal duty to disclose every single potential issue or correct someone else's incorrect assumptions, as long as you didn't cause those assumptions in the first place.
The caveat emptor rule.
Exactly. Caveat emptor, let the buyer beware, is still a strong principle in Singapore real estate. Buyers are expected to do their own homework, ask questions, get inspections done.
Okay.
However, and this is a big however, for agents, you absolutely cannot actively mislead buyers or tell half-truths. And you definitely cannot lie if directly asked a question.
So, I can't lie if they ask about the roof, but I don't necessarily have to proactively announce every minor creak in the floorboards. That sounds like a tricky ethical tightrope to walk.
It can be. Honesty and transparency are always the best policy professionally, even if the law doesn't always require full disclosure. But there are important legal exceptions to the silence rule, too.
Like what?
Well, if you make a statement that's technically true but incomplete, and the omission makes it misleading, that can be misrepresentation. For instance, saying a property is fully tenanted, but conveniently forgetting to mention that all the tenants have just given notice to leave.
The half-truth.
Right. Also, if something changes after you've made a statement that was true at the time, making it false before the contract is signed, you generally have a duty to correct that statement. Failing to correct it can amount to misrepresentation.
Those sound like crucial ethical and legal lines in the sand for any real estate professional. What about inducement? The false statement has to actually be one of the reasons the person decided to enter the contract, right?
Absolutely. The false statement needs to have played a real and significant role in persuading the other person to sign the contract. It doesn't have to be the only reason, maybe they like the location too, but it has to be a contributing factor.
Okay.
Interestingly, even if the buyer does their own checks or gets their own reports, it doesn't automatically mean they weren't induced by your misrepresentation, unless they actually discovered the truth before signing the contract, or they made it clear they completely disregarded your statement and relied solely on their own findings.
Okay, so you can't just say, well, they should have done their due diligence better if your false information actually played a part in their decision. Now, your notes outline 3 types of misrepresentation: fraudulent, negligent, and innocent. These sound like they range from deliberate lying to genuine mistakes.
That's a good way to categorize them. Fraudulent misrepresentation is the most serious. This is when you make a false statement knowing it's false, or you don't believe it to be true, or you're just reckless about whether it's true or not, basically. You don't care if it's true, and you intend to deceive the other party. It's deliberate dishonesty.
Like lying about termites you know are there.
Exactly. Your example of someone knowingly hiding a termite infestation is spot on. That's fraud.
Ouch. That sounds like a fast track to a lawsuit and losing your license. What about negligent misrepresentation?
Here, you might have actually believed your statement was true, but you didn't have reasonable grounds for that belief. You didn't take reasonable care to check if it was accurate. You were careless with the facts.
So still made a false statement, but didn't necessarily intend to lie.
Right. There's no deliberate dishonesty, but there's a lack of reasonable diligence. So in our termite example, if an agent honestly thought there were no termites based on a quick look, but hadn't bothered to recommend or check for a proper pest inspection report when one was clearly needed and termites were later found, that could potentially be negligent misrepresentation.
Okay, so honest belief, but sloppy groundwork. And finally, innocent misrepresentation.
This is when you genuinely believed your statement to be true, and you had reasonable grounds for that belief. You acted reasonably and honestly, but the statement still turned out to be false, perhaps based on incorrect information you received from a reliable source, like the owner or official documents, despite your checks.
Like maybe misstating the exact square footage based on architect plans that later turned out to have a minor error.
Possibly, yes, if you reasonably relied on those plans. You acted responsibly and honestly, but the statement was still factually incorrect. Imagine an agent innocently misrepresents the size of a balcony based on incorrect official floor plans they reasonably trusted. If the buyer incurs costs to rectify this after purchase, like adjusting built-in furniture, an indemnity might cover those specific directly related expenses.
Okay, indemnity.
Unlike broader damages, which could cover other losses like disappointment or loss of expected profit.
So it all hinges on your state of mind. Did you know, were you reckless? Were you just careless? Or were you genuinely mistaken despite being careful?
Yeah.
And whether you acted reasonably. Now, if there's a misrepresentation, what can the person who was misled do about it? What are the remedies?
The available remedies depend heavily on the type of misrepresentation. Rescission, essentially canceling the contract and putting everyone back in their original positions as much as possible, is available in principle for all 3 types: fraudulent, negligent, and innocent.
Hitting the undo button.
Pretty much. Any money or property that changed hands generally has to be returned. However, the right to rescind can be lost, for example, if too much time passes, or if it's impossible to restore the parties to their original positions, or if an innocent third party has gained rights.
Okay. What about getting money back for any losses suffered?
That's where damages come in. These are monetary compensation for the losses you've incurred because of the misrepresentation. Damages are definitely available for fraudulent misrepresentation. They are also available for negligent misrepresentation under the Misrepresentation Act.
And for innocent.
For innocent misrepresentation, the primary remedy is usually rescission. The court generally doesn't award damages as of right. However, the court does have the discretion under the Misrepresentation Act to award damages instead of allowing rescission, if it thinks that would be more fair or equitable in the circumstances. And as we touched on, for innocent misrepresentation, sometimes an indemnity might be ordered alongside rescission. This is compensation for expenses necessarily incurred because of obligations created by the contract itself. It's generally narrower than damages. Your notes have a very handy table summarizing these remedies, definitely worth studying.
Yes, that's definitely going to be highlighted in my study notes.
Okay.
We're nearing the end of a contract's life cycle now. How does a contract discharge or come to an official end? Your notes mention 4 ways.
That's right. 4 main ways contractual obligations cease. The most straightforward is by performance, where both parties have fully carried out all their obligations exactly as promised in the contract. Job done.
Simple.
Then there's by agreement, where both parties mutually decide to call it quits and end the contract, perhaps through a new agreement.
Okay, they just agree to walk away.
Yep. Thirdly, by breach. Specifically, when one party breaks a condition of the contract, remember a fundamental term in a significant way. This gives the innocent party the right to treat the contract as discharged, effectively ending their own obligations, and also to claim damages for their losses.
So, a serious breach kills the contract.
It gives the innocent party the option to kill it. And finally, by frustration. This is a tricky one. It happens when something unexpected occurs after the contract is made that's beyond the control of either party, which makes the contract impossible to perform or radically different from what was intended, or maybe even illegal to perform.
Like if the specific property being sold burns down before completion.
Exactly. That's a classic example. Or maybe a sudden change in the law makes the contract illegal. In such cases of frustration, the contract is automatically discharged, and both parties are released from their future obligations under it. No one is considered in breach.
So, no one's fault, just unforeseen events that derail the whole agreement. Now, what happens when someone just doesn't hold up their end of the bargain and there's a breach of contract, but maybe it's not frustration and doesn't discharge the whole thing? What legal remedies are available then?
Right. So a breach of contract is simply failing to perform your contractual obligations without a lawful excuse. The main remedy the court usually awards is damages.
Money again?
Money again. Financial compensation to put the injured party in the position they would have been in if the contract had been properly performed, as far as money can do it.
Okay.
In real estate, if a seller backs out without justification, damages might be the difference between the agreed-upon contract price and the higher market value of the property at the time of the breach, plus any wasted costs. The court can also award damages in addition to or sometimes instead of other remedies. Your notes mention a local case, Muhammad Ali v. Tan Abi,
Ah, yes, the example.
where the court awarded damages, including interest for the delayed completion and even the rental costs the buyer incurred because they couldn't move in on time due to the seller's delay.
That gives a real-world example of how damages can be calculated in a property deal. What about when money just isn't enough to fix the problem? I see specific performance mentioned.
Yes, specific performance is an equitable remedy, meaning it's granted at the court's discretion. It's a court order compelling the breaching party to actually do what they promised to do in the contract to perform their side of the bargain.
Forcing them to go through with it.
Exactly. It's a remedy often favored in real estate deals because land and property are generally considered unique. So just getting money might not truly compensate the buyer for losing out on that specific property they had set their heart on.
Makes sense. You can't always just buy an identical house next door.
Precisely. The court can even order specific performance along with damages if, say, performance was delayed and caused additional losses. So I want that particular house, not just its monetary value, can be a winning argument in court.
Okay. And finally, there's injunction.
An injunction is another equitable remedy. It's a court order that tells someone to stop doing something, particularly if they've promised not to do it in the contract. That's called enforcing a negative covenant.
Okay, stop order.
Right. In real estate, a caveat lodged on a property title acts a bit like an injunction in practice. It freezes dealings on the property, preventing the owner from selling it to someone else, for example, until the dispute related to the caveat is resolved.
Okay, so that's a whirlwind tour of how contracts can go wrong and how the law tries to put things right. Now, let's zoom in on real estate specifics in Singapore. We've already hammered home the point that they have to be in writing. What else is crucial for RES exam takers to know here?
Well, as we've emphasized, that written rule under the Singapore Civil Law Act, Section 6D, is absolutely fundamental. Don't forget it. And the most common document you'll encounter in private property sales is the option to purchase, or OTP.
The OTP, the star of the show.
Pretty much. Sometimes a full-blown sale and purchase agreement, or S&P, is used right from the start. But the OTP is the more typical first step for resale private properties.
Okay.
Now, for brand new, uncompleted properties sold by developers, and also for resale HDB flats, there are standard prescribed OTP forms.
Standard forms.
Yes. Form B is the standard OTP for uncompleted private properties, and HDB has its own standard OTP for resale flats. There are also standard S&P forms, like Form E for uncompleted private properties, mandated by the housing developers' rules.
And you can't mess with those.
Not easily. You can't just tinker with these standard forms for uncompleted properties without getting approval from the controller of housing. And for HDB resale, you must use the standard HDB OTP. No other side agreements or variations are legally valid for the option itself.
So less room for creative negotiation with those types of properties. Let's really focus on the option to purchase for private resale, the most common scenario agents deal with. What exactly does this all-important document do?
Think of it as the seller giving a potential buyer an exclusive, legally binding right, but not the obligation to buy the property at a specific agreed price for a set period of time.
An exclusive right.
Exactly. In exchange for this right, the buyer pays a non-refundable option fee. Typically, this is 1% of the agreed sale price for private properties, though it can be negotiated. For HDB resale, it's a smaller fixed sum, usually between $1,000 and $1,000.
Okay, 1% for private is the norm.
It's the common practice. This fee buys the buyer that crucial window, usually around 14 days, sometimes longer if agreed, to decide if they want to go ahead with the purchase. During this time, the seller cannot sell or offer to sell the property to anyone else. It's like putting a reserved sign on the property just for that buyer.
Okay, 14 days is typical, and the seller is stuck with that buyer during that time.
The seller is legally bound. They cannot accept any other offers during the option period.
Got it. So what are some of the really important OTP rules that are likely to pop up in the exam? What needs to be in the OTP?
Okay, several key things must be in a valid OTP. First, all the essential details. The full names and details like NRIC passport numbers, addresses of both the buyer and seller, a clear and precise description of the property, the full address, unit number, maybe the lot number or strata lot number.
Property ID is crucial.
Absolutely. The agreed upon purchase price and clearly stating the amount of the option fee paid and the further sum payable when the option is exercised, often called the exercise fee or deposit balance. Those specific percentages mentioned in your notes for private, like 1% option fee, 4% or 9% exercise fee, and the structure for HDB uncompleted are vital examples to know.
Price breakdown, got it.
All the important dates when the option is granted by the seller, the exact date and oftentimes the option expires, and the expected completion date for the sale, usually 8, 10, or 12 weeks after exercise, but negotiable.
Timelines are key.
Very key. And who the stakeholder is. This is usually the seller's law firm who will hold the buyer's deposit, the exercise fee, in their client account until completion.
Okay, the neutral holder of the deposit. Got it. All the crucial information laid out clearly. What else is important about how the OTP works?
Well, as we said, once the seller grants the OTP and receives the option fee, they are legally bound to sell the property only to that specific buyer, or their nominee if allowed, at the agreed price, if the buyer exercises the option during the option period. It's an irrevocable offer from the seller for that period.
Irrevocable for the seller.
Correct. They can't market the property to anyone else or accept a better offer that might come along during that time. Now, if the OTP includes the magic words and/or nominee,
The nominee clause.
it means the original buyer, named in the OTP, has the right to nominate someone else, maybe a family member, maybe a company, to be the actual buyer who exercises the option and completes the purchase.
Flexible for the buyer.
Can be. However, remember, this nomination is not allowed for HDB resale flats. The original buyer, named on the HDB OTP, is the only one who can exercise it. No nominees allowed there.
Good distinction for HDB. So the seller is in a temporary holding pattern. But the buyer isn't forced to buy, are they?
Nope, absolutely not. The buyer, or the person holding the OTP, has the complete freedom to choose. If they decide not to proceed with the purchase for any reason, maybe they couldn't get financing, maybe they just changed their mind, they simply let the option period expire without exercising it.
And the consequence?
The only consequence for the buyer is that they forfeit the option fee they initially paid. That 1%, or whatever amount it was, is gone. That's the price they paid for having that exclusive right and time to decide.
Buyer gets a no-pressure decision window, losing only the option fee if they back out. While the seller takes a temporary risk of the market changing, but gets to keep the fee if the buyer walks. What happens if the buyer decides they do want to buy the property?
If the buyer decides to go ahead, they must exercise the option strictly within the agreed time frame, and usually in the manner specified in the OTP. This typically involves signing the acceptance copy of the OTP and delivering it, along with paying the remaining deposit, the exercise fee, to the seller's lawyers or as stipulated.
Okay, sign and pay the rest of the deposit.
Exactly. Once the option is validly exercised, a legally binding contract for the sale and purchase of the property is fully formed. At this point, both parties are locked in. Neither party can back out without facing potential legal consequences, like being sued for breach of contract, unless assignment or nomination was specifically prohibited in the OTP itself.
So exercising the OTP creates the binding contract.
Yes, for private resale typically. Now, for new, uncompleted properties, developers often do restrict assignment or nomination. And remember those specific rules we mentioned for changing the buyer's name on an uncompleted property OTP. It's usually very limited, maybe deletion of a name, adding an immediate family member, or substituting one immediate family member for another. Typically, only one such change is allowed, and it usually requires the controller of housing's approval, often resulting in a fresh OTP being issued.
Those are some very specific rules for those new builds, definitely worth highlighting in your exam prep. And what if the buyer just lets the option period run out without doing anything?
In that case, the option simply expires. It lapses. The seller is no longer obligated to sell to that buyer. The seller gets to keep the option fee free and clear.
Seller keeps the fee.
Seller keeps the fee. It's compensation for taking the property off the market during that period. The seller is then completely free to market the property again and sell it to somewhere else. For those uncompleted properties, if the buyer doesn't exercise the OTP, the developer usually has the right, under the rules, to forfeit a portion of the initial booking fee paid, often 25% of it, with the remaining 75% being refunded to the buyer. Then the developer is free to put the unit back on the market.
Okay, so the OTP is a really critical first step in most private property transactions, creating that initial binding right. What about the actual content of the sale contract that comes after the OTP is exercised, or if a full sale and purchase agreement, S&P, is used right from the start? What goes into that?
It will essentially formalize and expand on all the key terms that were initially agreed upon in the OTP, along with more detailed conditions for sale. These often include general conditions, which are standard legal terms commonly used in property transactions in Singapore, for example. The Law Society of Singapore's conditions of sale are often incorporated by reference.
Standard legal stuff.
Right, the boilerplate. But there can also be special conditions. These are clauses specifically negotiated and agreed upon by the buyer and seller for that particular transaction, often to modify or add to the standard general conditions.
Custom terms for the deal.
Exactly. Your notes give a good example. If the property is being sold with existing tenants, there will likely be special conditions detailing the terms of that tenancy, the rent, the deposit transfer, etc.
So the general conditions are the standard legal framework, and the special conditions are the custom tweaks for that particular deal. What about this phrase, subject to contract? It sounds like a potential escape clause. When might we see that?
You sometimes see it in initial offer letters or maybe even noted on an OTP, though less common on the standard exercise. It essentially means that even if there's an initial agreement in principle, the parties intend that there will be no fully legally binding contract until a further formal document, usually the comprehensive sale and purchase agreement, is properly drawn up, agreed upon, and signed by both parties.
So even after the OTP is exercised, if it was explicitly done subject to contract, the sale isn't absolutely set in stone until that subsequent formal S&P agreement is inked.
Correct. It signals that the initial agreement is conditional upon the finalization of a formal contract. It adds another layer before things become fully binding. You need to be aware if that phrase is used.
Interesting nuance to be aware of. And finally, your notes mention by deed versus by hand. That sounds like something from a historical drama. What's the relevance?
It does sound a bit old-fashioned. But it highlights a historical and still valid exception to the rule about needing consideration. A deed is a very formal type of written legal document that has specific signing and witnessing requirements. Historically, it was made under seal, think wax seals. The key point is, a promise made in a properly executed deed doesn't actually require consideration to be legally binding.
No consideration needed for a deed.
Generally, no. The formality of the deed itself is seen as showing the necessary intention to be bound. While you don't see physical wax seals much anymore, the legal principle remains that a document executed and delivered as a deed carries a special legal weight, making promises within it enforceable even without explicit price or consideration being exchanged for that specific promise. It's an exception to the usual consideration rule.
Okay, let's take a deep breath. Wow. We've just navigated a huge chunk of Singapore contract law, focusing specifically on exactly what you need to know to confidently tackle your RES exam.
We really covered a lot of ground there.
We've covered everything from the fundamental building blocks of what makes a contract to who can make one, the specifics of property transactions, and that all-important option to purchase.
And don't forget the pitfalls. We explore the critical differences between contracts that are valid, void, and voidable, the significance of conditions versus warranties, and the potential minefield and remedies related to misrepresentation.
Absolutely. Make sure you revisit the real-world examples, those specific rules we discussed from your notes. They'll be your best friends when you're preparing for the exam. Remember, a solid understanding of contract law isn't just about passing a test.
Though that's important.
It really is. But it's also the bedrock of ethical and successful real estate practice here in Singapore. Knowing this stuff protects you and your clients.
Absolutely. Keep reviewing these concepts, maybe talk them through with study buddies, test yourself with practice questions, and remember why this knowledge is so vital for your future career.
We wish you the very best of luck in your upcoming RES exam.
Yeah, all the best. Go out there and ace it.